Well, it says we're live. Hopefully, we're live. I don't have my phone to check, so
I probably could do that.
I think we got the sound on. But for those of you who are watching live, thanks for joining us. And if you're watching this later after we recorded it, today is January the 14th?
15th.
15th, geez. Already halfway through the month of the first month of the year. January 15th, 2025. And this is going to be our first podcast for 2025. And since we were really busy over the holidays and just the end of the year grind, this will be an update, short little update and more to come later. But for today, just a quick update for where we are at as a foundation, and then what happened yesterday. We had some big news come through yesterday. So first off, Pete, welcome back from the campaign. It was a grind.
It was a grind.
Tell me, I was basically holding down the fort here at the all last year, and had my other things going on, so I didn't get deep into the campaign. I did that probably to save my own sanity more than anything, probably selfishly. So, but we've had some conversations, and you saw a lot going around the state. What are some takeaways you had from being around, meeting with the people? And obviously, you were out there, evangelizing our foundation and the work we're doing here. So what's kind of some of the things you're hearing and seeing from the people of Washington State?
So, I mean, from the foundation standpoint, I think obviously we need to get the message out there, because there were a lot of folks that weren't aware of what we're doing. There still remain a lot of folks that aren't aware of what we're doing. So that's where having the assistance from people that support us to shout us out is super critical. To know that someone's actually out there taking swings at the legislature, taking swings at the governor, taking swings at other elected officials, and saying, you can't hammer on our rights. So getting that message out there is critical, and that it was beneficial in that element. I do think, I've had calls since the campaign of folks up on the west side that are looking for assistance. We've talked about this, you and I, a lot. You see what's going on in like the China International District and the homelessness. People are wondering how they can protect their property in a way that if the city's not going to do it, and I can't just go shoot the homeless guy, I'm left with a lawsuit. And folks are looking for help there. People are looking for help up on Capitol Hill from the destruction that continues because the city's bad policies. So the notion that, yes, Seattle is dying, there's no question about it, but there are folks that want to keep it or revive it. So I think it's not as far gone as some folks like to believe or do believe. And certainly I say that, in the wake of a loss, largely due to King County. So I understand that, from the political standpoint, while we may not have seen the results we wanted, there remain a lot of folks that are out there trying to figure out how to navigate daily life within that system, but also holding the government accountable. So I do think that we're going to see some, maybe not necessarily alliances, but we're going to see some interesting stuff from the foundation standpoint, where we will have some colleagues or friends that aren't natural alliances.
So, that's a lot. You saw a lot. There's a lot going on in the state. And for those that, didn't follow along with the campaign, you were running for attorney general, and primarily because, this is my own words, because you were trying to fix things from the inside, right? Go on the other side of the battle and try and fix things from the ground up. Obviously, that didn't work. So now we've got to fight from the position we've had since our inception in 2021 to try and fix the state, and then push back federally if we have to. Obviously, things have changed quite a bit nationally as well. So we got a lot going on, a lot on our plate. So let's talk a little bit about some updates on some of the stuff. Just quick little updates. Some of the stuff that's continued to be on our plates that's carried over from 2024, and then what happened yesterday. So I think we're going to start with the Peace Health update. What's going on with that?
So that case, for anyone that doesn't remember Peace Health, we had 53 or have 53 plaintiffs that are suing Peace Health, hospital organization, treatment provider, essentially, primarily in Southwest and Northwestern Washington. And these individuals are suing for the violation of their civil rights under Title VII of the Civil Rights Act, which protects an individual's creed or their religious purposes. So these individuals objected to the COVID-19 vaccine mandate, were placed on indefinite leave without pay for about 2 years, and then were eventually terminated. That case has gotten really hot in discovery. For anyone that's not a lawyer, that means that right now it's a lot of paper pushing. We ask questions of Peace Health. They answer, they can object, but typically you object and then answer at least partially. And they've asked our 53 plaintiffs some questions about how did this impact you? How did it impact you financially? How do you claim your rights were violated? Some base things that we've already pled that fortunately we can build upon and show the record that there is an actual violation of these rights. In addition, we've each submitted expert witness reports. We have Dr. Harvey Risch on our side. They have a gentleman, doctor out of University of Washington, a medical school. It's going to be really interesting to see. So each party has submitted their own reports to the other, and now we get to take it back home, and then our experts basically tear each other apart. So it's like, this is what I say, this is what you say. Now I get to complain about, or, attack what you've said. And so it's going to be interesting when we, probably at the end of this month, January, we'll have the rebuttal reports, what those are called. And so when we get those, it'll be interesting to see how each doctor approaches one another. And that'll lead us into what's called dispositive motion practice in March, which is where we're going to basically say, this is an issue that, based on the evidence and everything we have before us, is a live issue, and it's got to go to trial. We do that, I think it really leads us for success. Obviously, if we lose on that, that's the threshold issue, and the case is dismissed, which I don't foresee that happening.
Gotcha. So, how much of this case is going to bring in any of the newer information that we're seeing? For example, just recently released, there was, I think, a study that included 99 million people had taken the shot. Is any of that kind of stuff going to be brought into this case, or is this going to be primarily on what happened in the time period at hand when these people were losing their jobs or being put on leave?
Really, it's stuck in a time loop. So we're going to have, at least for right now, the issues that we're looking at are kind of what was known at the time. Because if we can show, and I believe our expert did this successfully, that Peace Health could have accommodated these people and anyone else that it put on leave without, an undue burden is the threshold kind of legal statement, which means it used to be a very small burden. Now I think the Supreme Court actually clarified it last year and said, no, this actually has to be a real burden on you. So, you can't just say it's going to cost us more in PPE and masks and gowns. It's got to be something that's going to either impact your bottom line, or you're never going to have the resources, human resources, to provide. And so I think that our expert was successful in showing that the undue burden standard won't be met by Peace Health. Even looking backwards to 4 and 5 years ago, what we know now, I think you're right, is going to just help us. But I think because this is a jury trial, that information helps looking at the psychology of a jury. That's down the road, probably a year and a half if we don't settle. And this same expert was the expert on the Bay Area rapid transit case out of San Francisco, where they successfully won about 1.2 to 1.4 million per head on 7 individuals who refused to settle. Wow. And the other mass part actually settled early on. So I think this case to me is coming at the right time in the right place, right information. And again, I think, as you mentioned, you're looking at people, the general population is getting more information about how dangerous, how unstudied these vaccines were, and how harmful they could have been. And that these people had a real basis to object.
Great. And sliding right into that on the same sort of vein, we're representing Dr. Moon, who was working at WSU as a professor, and she has a very interesting case. And this is a First Amendment case more than anything. It's been interesting seeing that. We saw the case for the coach, Coach Rolovich, I believe, that didn't go in his favor. Hasn't gone in his favor so far. Um, and I don't know if you've had time being as busy as you have to even read that case, but what sets Dr. Moon's case apart from what else is going on in the world?
I haven't read the Rolovich opinion. A couple of things set it apart. You know, the Rolovich case is a pure. It's more like the Peace Health case, where there was a vaccine mandate. He objected to it based on religious reasons, and then they fired him. In Dr. Moon's case, there are two kind of sides of this case. There's the academic freedom, where prior to COVID, she had had some very limited disciplinary history for basically not speaking the corporate mantra. And some of the students complained, and they put her on a improvement plan and pulled her from certain courses because, God forbid, she actually taught from her personal experience, but it wasn't, alongside or aligned with some of those woke ideologies. And so there's that element of the case. But what really bit her on the back end was she went out to U.S. Senator Ron Johnson's COVID-19 roundtable discussion, and she held up the insert of the COVID vaccine and said intentionally blank. And after she went out and did that, the university not only did not renew her contract, but also one of the deans submitted that statement to the Washington Medical Commission for her license, to inquire whether or not she was fit to practice medicine. Sadly, fortunately, we represented her in the medical licensing case and were successful there, defended, and she ended up just dismissing her license. She let it go. She let it lapse, and they still came after her. After she didn't renew her license, they still came after her. And so eventually we got that dismissed. And so now we're fighting for her right to speak freely, not only in the classroom, but outside of the classroom. And so this case has some serious impacts on what does academic freedom mean? What does it mean when you're a professor, whether you're tenured or not? What does it mean to speak at a university? And there's some great case law out of the Ninth Circuit, which is our federal appellate circuit. There's some great case law that talks about, when you're speaking in a classroom, you have protected speech, and you can even use racial epithets. You can use swear words. You can use vulgar terms as long as you're basically engaging in discourse that's beneficial to the public. In other words, you could say, well, I'm saying, use the words, but I'm saying some raunchy terminology.
We're not in the classroom, so we can't really say
exactly.
those
We're on a podcast. We're not protected here.
We are on X though, and it sounds like Facebook's supposed to be more free, so we'll find out.
Maybe I'll start dropping those words. But anyway, there's some great case law, and I think Dr. Moon is going to be a beneficiary of some of those recent decisions that talk about that the line is pretty limited in where you can tell a teacher not to speak. And then obviously having spoken at the Johnson hearing on her own time, on her own dime, not associated with WSU, just as, put in her resume that she was a pediatrician of 20 plus years, that sort of thing. There's a whole distinction of, you held the position, but you weren't using the position to, advance the conversation. And so that case is moving. There was a motion to dismiss certain defendants, and we spent the past several weeks right after Christmas responding to that. And I think we've got some pretty solid arguments, and I think those arguments will keep those individuals in. And the nice thing about that is it had us go back through the records, and we may even add more to the complaint. And if that's the case, then I think we build an even stronger record to advance this case.
What kind of a timeline do you think we have on that case?
They'll respond to the motion to dismiss or reply to our response in 3 weeks from the day that we filed that. That was last Monday. So in about 2 weeks, they'll have that, and then we've got a new judge in the case, Judge Pinnell, who's recently appointed to the federal Eastern District of Washington out of Spokane. I don't know much about her. I believe she was on the bench in the Court of Appeals here in the state of Washington. Don't quote me on that. I'm sure someone will Google that and tell me why I'm wrong. But yeah, I mean, so, I don't really have, some of these judges will rule very quickly, 3 weeks, 4 weeks. Some, I mean, we sat on one for what, 11 months?
Yep.
I mean,
Right at that.
yeah. So it's moving forward, and that's going to help us with discovery.
Okay. And then another one similar with free speech is the Morrow case. Where were we at with that?
Yeah, that case, we filed that case, I think right around election time, right before, I think. And we got an answer just yesterday, or maybe Monday. And so usually the MO is to seek to dismiss some or all of the defendants. In this case, they didn't seek to dismiss anyone. They just straight up answered, which means that we're going to move into discovery. And at some point, I'm sure they'll bring a motion to dismiss or a motion for summary judgment, either of which would terminate the case. And, we're just going to move through and pass information back and forth to prove up Miss Morrow's case. So, and if anyone remembers, that was when we were on Dr. Drew, where we, had talking with him about the importance of her free speech.
Yeah. Well, speaking of Dr. Drew, he just recently posted something about being censored on YouTube.
I saw that. I responded to him.
Well, maybe he'll reach back out to us. Maybe we'll have YouTube on the other side of the court one of these days.
Yeah. Why not?
And then we have Dr. Wilkinson, of his case.
Yeah, that case has been sitting at the appellate court for quite some time, and we were supposed to have oral arguments by the end of last year, but that got bumped to the 22nd or 24th of this month. So early next week, we have a hearing on his case. So, we're working on making sure our arguments are tight. Obviously, we haven't visited that case for quite some time. So we're having to revisit it and just making sure that we're fresh on those arguments. That's all about his licensing and the fact that it should never have been pulled and that the state overstepped its boundaries. And so I think, I think one of these cases is going to have to crack, and at some point the state will be reined in on how it handles its medical disciplinary actions. But I'm hopeful that this will be the one. Simultaneously, Ryan Cole's got an appeal going, and his should be heard probably shortly thereafter. I don't have a date on that, but we're moving along in those cases. And again, enough people appeal these decisions. Eventually a court's going to come out and say, you know what, this is really what we meant. And these are the constraints, medical commission, on what you can do to or not to people's licenses.
I like it. Before we move on to the next topic, I just want to take this time to address some comments that we get on social media, some of our followers, or even if they're not followers, they just happen to come across our work. And we get criticisms for what we're doing and how we're doing it. One such is that we focus primarily on the Second Amendment or too much on something else or other. And I want to just take this time to remind our followers and people that are listening that we are a constitutional organization. We focus on all aspects of the Constitution of the United States. And whenever there's overreach and there's an issue that we see could be globally beneficial to address, that's how we do it. And we discuss it internally and prayerfully and thoughtfully think about what issues we are going to take up and how we're going to do it. And for those of you who may have seen a lot of our Second Amendment stuff going on, and not as much about our medical freedom or our First Amendment. It's just because the Second Amendment's been such a hot topic. We have a lot of people that support us because of the work we do for the Second Amendment, and so we want to keep them updated on what's going on. And primarily, it's been the biggest mover of what's been going on as far as for news and the news cycle goes. But as you could hear from the last half hour we've been speaking, we have a lot of medical freedom, First Amendment issues that we're still fighting, and that atrocity that was the COVID pandemic. We are still trying to fight for the justice of those people that were so greatly affected by that.
Before we get into the next one, it's looking at the list. You skipped one.
Oh, did I?
Yeah. What did we file right after the election?
I'm drawing a blank.
Fishy Fergie.
Oh, that's right.
Yeah.
We didn't put up on
Yeah,
the list.
we didn't put that one up. But and one of the other things we did, people asked, how did I relax right after the election? The answer was I didn't. Tuesday was the election. We were up in Seattle halfway through Wednesday, thanks to some friends, stayed in Clay Elum overnight the next night. And then back in the office, I think either Thursday evening or Friday. And either Monday or Tuesday after the election, we sued Bob Ferguson in the Attorney General's office and several of his executive people who no longer work there. They work for the new governor. Oh, wait, that's Bob Ferguson too, huh? Yeah.
So let's talk about that a little bit. Does that follow them? What?
Yeah, it follows them. I mean, they did the work. I mean, they're the ones that implemented the vaccine mandate. Back to your point about medical freedom. It's another vaccine mandate case
Right.
on behalf of 10 former attorney general employees, and all about religious freedom, refusing the vaccine, that sort of thing. This case will follow each one of them. It will technically not. I mean, it'll stick with the attorney general's office as the lead defendant. And we'll see how they respond, whether or not they answer this one or seek to dismiss these individuals. The interesting thing about this is, as we looked at Moon's case, some of these people, some of the defendants were like peripherally involved, and that's not a good statement. They had limited involvement. They had direct but limited involvement.
Mm-hmm.
A lot of these folks in the attorney general's case were like literally in meetings and discussing everything. So there's, for them to seek to dismiss these individuals, to claim that they didn't have knowledge or experience or participation, is going to be extremely difficult. So, these people are going to stay involved until till the case is over. Is my expectation. So, yeah.
So anytime we sue the government, people really want heads to roll, right? And they ask about suing in their personal capacity, or is it a professional capacity, or what it is. Is there anything? How exactly are we suing Bob Ferguson and those that perpetrated this?
Everybody's in their official and individual capacity or personal capacity. But I mean, the reality is, even when you sue them in that personal capacity, it's not going to go lean against their home. It's not going to take away their retirement. It's going to get paid out from state coffers. So, it's not like I sue you and you got to cut me a check. I sue you and your employer, in this case the state, is going to cover that. Right. So, to your point, a lot of folks, same thing with legislative immunity. And, I know this is a tangent, but, lawmakers are immune. This doctrine is longstanding. We're talking about from the institution of the United States of America, that lawmakers are immune from civil liability even when they make bad law. Now, I think I've mentioned this to you. The one way you get around that is it's not going to come from legislation of the people even here in Washington. But, if you had some federal legislation under the Trump administration that said we're going to pull that immunity, if you had lawmakers that were willing to agree, you could actually see that happen. And to me, that would be the about face of, the notion of take away my Second Amendment rights and I'll sue you. Go ahead, we'll sue you in court. Right? That's what we hear from some of our lawmakers. They'd be a little more reluctant to bring some of these iffy bills that are on constitutionally shaky grounds.
Oh, and so many of them we're seeing this year. It's just ridiculous. Yeah. It's crazy. Speaking of that, which now does slide us into that last point that we have there, the Parents' Bill of Rights. It's insane to me that we're having to fight for this, but not a surprise. I've pulled all my kids out of public school. You've pulled yours out of public school. We saw the writing on the wall when 2020 hit, and we haven't looked back. Other than geez, I wish I could take advantage of the tax dollars that I'm paying into the public school system. But right now, I get zip to help offset the cost of taking that burden on ourselves. But what's going on with the Parents' Bill of Rights right now?
Yeah, that case has a hearing. For anyone that's not followed it closely, the state. So we had the initiative 2081. The Parents' Bill of Rights was passed. It was enacted. The legislature adopted it, and then a certain group of folks decided to sue. The state was defending it, and we intervened on behalf of 4 different groups or individuals: Informed Choice of Washington, um, One Washington, Jim Walsh, and then Project 42. Was it Project 42? I can't recall how Brian Haywood. I think it was Project.
I think it's
42.
Project 42.
In Project 42, either as sponsors or folks that really worked to get the bill passed. And we were granted intervention status. The case had a motion for partial summary judgment, which is partially granted and partially denied. And so now, or no, preliminary injunction. And so certain portions of the record keeping and providing parental notification were, put kind of on stay, and other parts were let to go into effect. And we have I believe a motion for summary judgment is what we have, which would actually totally dismiss the entirety of the case, depending on how it turns out. If it's granted one way or another in its entirety, either the bill will be deemed constitutional or unconstitutional. That's a hearing that's happening next Friday in King County in Seattle.
Right. And just for the quick and dirty, obviously the initiative was to put Bill of Rights in place for the parents, for their protection, for their access to the records of the children. There's bills now being placed in the legislature that they're trying to basically cut parents out of any health care records, anything that the school districts or the state deems that parents don't need to know. Essentially cutting parents out of any decision making when it comes to healthcare. And these schools, many school districts are looking to put clinics in these schools so that they can give them healthcare, whether the parents deem it necessary or not. They will take the kids out of school, put them in a clinic, and give them the so-called health care or mental care, whatever it is, without any kind of permission from the parents, and then not even telling the parents that it happened. Essentially kidnapping these children and taking them out of the purview of their parents, which is absolutely insane. And once again, why our kids aren't in the public school system right now.
Well, it is, and it's why we decided to intervene on this, to make what's called the mature minor doctrine back at the forefront, which means if you're going to make your own healthcare decisions, you have to show that you're totally independent. So you can't be a 13-year-old living at mom and dad's, not emotionally, not mentally fit, not physically or fiscally capable of providing for yourself. If you are that 13-year-old who somehow is just crushing it and you're Doogie Howser or Macaulay Culkin, like, go ahead, do your own thing. But for the other, 99.99% of the kids out there, until you're 18 years old, you're not going to be doing that. It is very concerning that there's a bill that absolutely about faces the people's voice. Let's not forget where this stemmed from. It was you and I and other people collecting and providing signatures that petitioned to the legislature. That didn't come about because, a good conservative like Jim Walsh did this. I mean, he obviously sponsored it, and I'm not trying to take a knock at Jim, right? Like, it didn't go through this traditional legislative process where it was a product of Olympia. It was a product of the people. And the fact that now we have, I want to say it's Senator Peterson. I can't remember. No, it's not Senator Peterson. It's just out of Vancouver. I can't remember right now, but we have a legislator and other folks that would support overturning the people's voice. Total BS. Absolute BS. We cannot stand for this. We have to show up, and we've got a Substack coming out on that bill in the next couple days. So pay attention, and I think other groups like Conservative Ladies of Washington, pay attention to what people are saying about these bills and get active. The people's voice will have to overpower the legislature's authority. I'm very concerned about this one because it just shows that the left in Olympia does not care. And we always knew that, but to just blatantly do it within one legislative session to overturn it while it's still being litigated, total trash.
Right. Speaking of legislation and bills coming out, there's been an interesting one, and I haven't done a deep dive into it, but it concerns militias of all things. There are people in the legislature that are worried about militias. I don't know why they'd possibly be worried about militias. What do they know that I don't know that makes militias necessary? But basically, it sounds like they're trying to eliminate any case where an outside militia from outside the state or whatever would come in and interfere with what the state's doing. So what is it that they're trying to do that they're afraid that a military body is going to come in and try and stop them?
Yeah.
I
Well,
don't
I
know.
mean, it's all about illegal immigrants.
Right?
Yeah, I mean, as clearly it's about protecting. This state has given the middle finger to any federal legislation on immigration, and it's all about protecting those individuals and saying to the federal government, "You're not going to come round up." That was a question I got all the time. Is like, what are you going to do when you're attorney general about this? Well, I guess what I don't have to worry about that anymore.
No, no. But sounds like we might have to worry about it more at a local level, and what's going on there.
Yeah, I mean, I'm very hopeful that our federal and I am not a big government guy. I think if anyone knows me well, they know that to be very true. But there are certain things that with where we are in this state of Washington, I'm looking forward to the federal government standing up and saying, "Here's our muscle, we're flexing it.
Yeah.
You are going to be like the other 49 several states."
Right. Speaking of militias, someone made the point, I'm sorry, I don't know who it was, but it made me chuckle. It was like the left has been saying for so long, the Second Amendment only applies to militias. It only applies to militias. You have to be a militia to be able to bear arms. That's what it was all about. And now they're trying to eliminate militias. Believe that. So they're not just trying to eliminate guns. So eliminate the guns and eliminate the militias. Now there's no Second Amendment at all. So obviously we know that that's their playbook, is to just completely eliminate guns, and I don't know if we have it in front of us today or not, but I'd like to at some point dive into the amici of the opposing counsel and what their mission statements are and where they ultimately want to get to. But we probably don't have time for that today. Let's just talk about what happened yesterday in Olympia with Austin Hatcher and you sitting in front of the state Supreme Court.
Yeah, I mean, for anyone that's been under a rock, yesterday we're at the Supreme Court for the Gators guns hearing. I think it went well. Could we have done better? I'm sure we could have, but I think when you look at the room, a lot of the justices tipped their hands. I thought Justice Gordon McLeod did a great job of reining folks in to. I don't know that I agree entirely. She's didn't state, but indicated that maybe the large capacity magazines greater than 10 round might not be protected under the state constitution, but certainly it seemed to me that she believed that under the Second Amendment they're protected. Again, I don't necessarily agree with that first premise, but protection under the Constitution would result in a victory regardless of state or federal.
Well, so let's break it down a little bit. So we're talking about Gators Guns v. Washington State, where Wally Wentz, the owner of Gators Guns, stands accused of selling large capacity magazines. Their words, standard capacity magazines for AR-15s,
And most handguns.
as Pete Hegseth testified in front of the senators that the standard issue is 30 rounds for an AR-15.
Well, how many Glocks have 13, 15, 17?
Oh, absolutely.
Or
There's-
other, Smith & Wesson.
And that's another point that didn't come up yesterday, is that how many guns, just because of the way they are designed with the large capacity magazine built into the handle or are they no longer functional or being able to be sold or sent to Washington State, just because it doesn't make sense to send a gun without its magazine. So that's a little bit of the why is it that we were there in the first place? Why do you think why are we there?
Why are we there? So the genesis is the state issued what's called a civil investigative demand, which the attorney general says, here, sign this paper under penalty of perjury and tell me how bad you are. And really, that's what it is. It's a blank check for them to investigate you. Imagine when you were in middle school, you got a referral to office, and it's like, I know you need to go to the office, sign it, and tell me why. And you're going to do so under penalty of perjury. So if you lie, you're going to jail. That's, step one. We challenged that. And then the case, we had a great ruling in April of 2024.
Yeah, 2024.
Was that last year?
Mm-hmm.
Great ruling from the Judge Basher down in Calais County Superior Court, 55 pages that talked about, under the Second Amendment or under Article 1, Section 24 of the Washington Constitution, this ban is a prohibition on an integral part of a firearm, violating those constitutional protections. Basically, full stop. Of course, the state didn't like that, so they appealed to the state Supreme Court. The state said it would review it. In the interim, we had Commissioner Johnston decide that that there needed to be stay on in the injunction. So we had the 88 minutes of freedom, and then
So he determined that the injunction was dangerous to the public, and that's why he put a stay on it. It would be dangerous for them to continue to sell these magazines, which is sold the majority of the United States.
Yeah, 300 million plus in circulation.
But it would be dangerous for Washington to continue to sell those in the meantime.
Yeah, and in looking at our pleadings, and I'm going to hold this up, this is pretty much all of them.
Put it on the angle so you can see how thick
It's
that is.
a 3-inch binder.
All right.
Anyone that's got good eyes, it's a 3-incher.
Right.
Obviously full. That's most of the pleadings from the case, not all. That 3 inches of paper.
So so just to clarify, that's what was submitted to the court.
This is probably half of what's submitted.
Half of what's submitted to the court. So
because it doesn't have expert reports.
Right.
Doesn't have some of the early stuff.
So I make that clarification because despite how limited our time was or the argument in front of the court yesterday, it was very well briefed. Those justices all had plenty of information from our side, every argument, every angle, including from Amici, to understand where we're coming from and what our argument was, correct?
Well, yeah, and it was very clear that they had either read or been very well briefed on the arguments. I mean, even some of the questions that were out of left field very clearly went back to some form of pleading. And some of the questions, and I'm not just talking about questions for us, I'm talking about questions of the state, where the judges clearly referenced our pleadings. And so, the tough thing is you're distilling whatever 2,000-3,000 pages of documents into a 40-minute argument, which is cut in half, so 20 minutes per side. So the state opens up, they get 15 minutes, they reserve 5 for what's called rebuttal, which means they go 15, we go 20, and they get 5 to respond to ours. Now, the best part was, for anyone watching, in the rebuttal section, I think the Solicitor General got 5 words out maybe and got cut into by a question. So his 5 minutes of rebuttal was about 2.5 to 3 minutes responding to a question or two. And then I think it was even more than that, because I recall the Chief Justice looking at the clock. There's a little red, amber, and then, green, amber, red.
Mm-hmm.
It shows you how close you are to finishing your time. And then there's also a little digital clock on the side telling you how much you have left. But I remember seeing the red, and he had gone over, and the Chief Justice was like, okay, well, because you were responding to a question, I'll let you wrap it up. And he threw out another 2 sentences. But here's the reality. This is just a juxtaposition of whether or not a large capacity magazine or a standard issue magazine that exceeds 10 rounds is protected under the Second Amendment or under Article 1, Section 24. Those are the seminal questions. The crazy thing is the state is also seeking, if they succeed on those 2 questions, to have the case transferred out of Judge Basher's hands.
Wow.
So the remedy they're seeking is declare these things unprotected and send it back to the trial court with a new judge.
Yeah.
Which to me,
in Cowlitz County.
Yeah, I'd have to go to Cowlitz.
I like our chances there. There's some pretty good judges
Yeah,
still there.
I mean, clearly it's a bias.
Right.
It's hey, we can't go to someone that's already beaten us up once.
Right.
Um, yeah, I mean, there's so much information that we all held, and I will say this, that when you get up there, you have your thoughts, and you have 3,000 pages that you're carrying with you in your mind at some point. It's always hard to determine what the best deployment is, and I will give Austin Hatcher, mad props. He did a great job.
Right.
He brought, I love that he talked about tyranny and protecting us from tyranny, and that was the original intent.
Exactly.
And so, look, I think personally, I think we had more friendly judges than expected. Is that enough to hit a majority? I can't tell you that.
Yeah.
I don't, because there were a couple that were quiet,
Right.
and some asked some really odd questions that have really no bearing on the case.
See, logic dictates to me that those kind of questions, right, those out left field questions that are just so fringe to what the argument at hand is, tells me that they really are grasping for anything and everything that they can throw at this, because ultimately, in the heart of hearts, they know what is so plainly stated in the Second Amendment and Article 1, Section 24.
I would agree with that. And I also, one of the things, there were some questions that I really thought got into the 1240 line of questioning, which is House Bill 1240, the so-called assault weapons bans. Well, the state outrightly admitted that a trigger is an integral part.
Right.
In my recollection, and I'd have to look at 1240, is amongst the various upgrades or modifications, I think there's some certain trigger modifications that are banned under 1240. So are they going to come back to us and say, hey, we admitted this, I guess we'll agree and stipulate that gets stricken? And the answer we all know is no.
Right.
But I mean, the fact is, like, but where I wanted to raise that is there were some of the questions that Austin got along those lines. And he did a great job of answering them, but sidestepping them and not getting us into the 1240 analysis. Because my concern was, when I saw that type of question heading his way, I was like, oh crap, we don't want to do what I just said the state did, right?
Mm-hmm.
Like, we don't want to admit that, oh, maybe that's not protected. Oh,
Right.
maybe that law. We don't want to distinguish things, because the goal here is, regardless of how this case turns out, one, we are prepared to go to the U.S. Supreme Court if we have to, if they're going to take it. But we also want good analysis on what does the state Supreme Court think about firearms laws
Right.
under the state constitution. And that will drive everything else we're doing and everything else that has to be done. And that should drive what's across the street in Olympia, in the House and the Senate buildings.
Right. The other thing that I think that for the average, the average watcher or follower of what we're doing in the Second Amendment, they don't understand that getting in front of the Supreme Court about this particular issue with the LCMs, standard capacity magazines. To your point, we don't want to get into the other arguments because we're having to fight this on so many different fronts, and that's what the opposition absolutely wants and understands, that they've only been able to make the progress they've made by taking these incremental steps that they're taking. And they're going to continue to take these incremental steps. And as long as we keep giving ground, that's where they're going with it. I've talked to a number of people that I know personally are pro Second Amendment that may feel a little bit more, like what may be more logical, or that seems like that might be a good decision. Or, there's some people I know that I don't think they should be able to have that kind of a gun or whatever. And I have to remind them, this isn't about a couple people. This isn't about a certain kind of gun or a certain kind of issue. This is about the base issue, that our right to bear arms. is God given. And the Constitution simply just outlines and instructs the government to stay away from that.
Well, and what you just said there is very akin to a line of questioning that Austin got, which is about what's called the Jorgensen case. And that was a case where a guy was out on recognizance and then gets a firearm and creates another dangerous crime, right? And then he gets his gun rights revoked temporarily. And the question is, well, under Jorgensen, we've got reasonable regulation, is what the Supreme Court said is appropriate. And it's like, okay, well, Jorgensen was about Jorgensen being a total a-hole, right? And a bad dude. And the Supreme Court said, we can do this under these circumstances. He has already had a hearing. Not, to your point, you and I not being able to get a gun because there's a red flag law, or because there's a firearms ban, or because they modified the licensing process. I mean, to hell with that. It shouldn't even be licensing.
Right.
But that's another separate issue. So, I mean, look, where I take away from yesterday is, I mean, I'm always going to say there's room for improvement. There's no question about that. But I thought Austin did a phenomenal job. I think he did a great job of answering those stray questions without veering too far into our other cases. And the reality is, if the justices can't make a decision based on 2 or 3 of these, and they need 40 minutes of discussion, we're in a bad situation.
Right.
Usually, the hearing is, quite frankly, it's more for show.
Oh, absolutely.
It's for public consumption, and whether or not it's checkbox for them to say we did it, or whether or not it's a way for us to shine, I don't know what it is. I enjoy hearings. I think it's fun.
Mm-hmm.
But I largely don't ever say, there are instances where I think pleadings can be like so close, like it's a real close question,
Mm-hmm.
that absolutely the hearing will push a judge or group of judges or a jury over. Obviously, in a jury trial, you have a lay jury, and that's a whole different situation. But when you have judges, I think, if they hadn't made up their minds before yesterday, I don't know that any immaculate performance would push 5 of them over the top to convert to our side, right?
Right.
That said, I think what we've put before them is an ample record, replete with information, historical analysis included for Bruin's sake, which I don't think is what Bruin says.
Right.
But that's what people have interpreted it as meaning. Constitutional analysis and expert opinion that really shows that these items should be protected under either or both the Second Amendment and the Washington Constitution. Now, I don't think I say that as a biased individual. I say that as someone who's lived this for 2 years, and I don't see how the state can see what it sees.
Right. Well, and we did all of that despite the fact that really all that was necessary to prove our point was to present the Constitution and the Constitution of the state of Washington, and they should stand by themselves. It's very clear what they state and why they state and how they state them. The fact that we're to this point where we're having these nonsensical arguments is, it's just a testament to where we are at currently in the culture and society, and how much we have to pull back the reins, and why it's necessary that organizations like ours exist, even though we think it's the dumbest thing in the world.
Yeah, I mean, it's all extremely unfortunate. It's unfortunate that we have to fight for this. It's unfortunate that we have to fight like we have to. And to your point, it should just be, hey, here's the Constitution, read it, and, it's done deal.
Right.
So
we kind of come to the end of this, but I kind of want to do a quick lightning round to end it off of. And the question that we have up there is, what's next? And I want first
specific to Gators, right?
specific to Gators. What's next? What's the ideal situation? What are possible situations? And then what's the likely situation that we have coming up?
Okay, next is hurry up and wait. The judges, I will say this. We were the very first hearing of the winter 2025 term with a newly elected justice. I mean, I think when you look at that, they could have pushed us back anywhere.
Hmm.
To me, it signifies they understand the importance of this case.
Right.
So my hope is a decision. I'll say within 90 days. I'd hope it'd be slightly sooner. It could be up to 4 or 5 months. There's no time limit. Let's be clear on that. So, like, when I prognosticate, don't call us on day 91 and say, where the hell's Gators?
Right.
I don't want to hear that.
Right.
You'll see it when we see it.
So yeah. So what
And
he's saying
I
is
assure you, I'm not writing it, because if I was, it'd be Judge Basher was right. The end.
right. No news means there hasn't been any movement,
Yeah.
and we are in a sit and wait situation. Now, that doesn't mean that we may not come out with some updates
Yeah.
or some talk about where we currently see things, or maybe some updates of what's going on nationally, because there's some cases that are sitting to be scheduled with the Supreme Court of the United States that may have some bearing on this. So
Absolutely.
ideally, we have a decision in the next 90 days.
Yeah, give or take by let's call it Easter time. Get a decision around then. And again, Pete's ideal world, we win on both questions. Obviously, it's not sent back or remanded to the Cowlitz County Superior Court, which the magazines are protected under Article 1, Section 24. We understand why. They give us a real roadmap, and then we understand why, whether or not they punt and say, well, under Bruin, this really is pre-analyzed for us, and here we are. Under the Second Amendment, that's obviously my ideal, kumbaya world.
So with that favorable decision, then can the state come back and try and do anything after that?
They could appeal the U.S. Supreme Court, but I don't know why why the Supreme Court would take it.
Chances are pretty slim.
Yeah, I mean, I can't imagine the Supreme Court saying, "Well, we were wrong in Bruin, so."
Could a legislature's backdoor another thing and ban them in a different way?
Well, I don't trust our legislature, so yeah, absolutely.
Okay.
I don't know. I mean, it really all depends on what the analysis looks like. I mean, I think the legislature would be, because of the immunity, right? They're emboldened to kind of do whatever. So there's that risk. But I think it'd be low risk, low probability, maybe.
Okay. So I know I'm getting off of the ideal issue, right? So
No,
ideally, we have a favorable decision,
under both
and
constitutions.
and magazines are back on the shelves, and we can purchase the guns and magazines that we've all been able to up until 2023.
Right. But more importantly, that analysis also helps us in our Guardian Arms, the 1240 case, and the other cases, right? So in the ideal world, we've got, a pathway to success everywhere, but success here, launched on this success. The possible world, or more plausible world, possible world, you could have the exact opposite of that,
Right.
where they don't say that either the Constitution is protected, and obviously the possibility is the ideal too. I don't know that that's a strong possibility, so that pushes me into likely. Personally, and I've said this for a while, I can totally see the court saying, Article 1, Section 24 of the Washington Constitution, even though it's more absolute than the United States Constitution, we're not going to really touch the deference of the legislature. And so maybe they're going to find a way to weasel out of the state constitution. But I could also see them not wanting to get overturned and saying, well, the Bruin test is pretty clear, and we're kind of stuck with, when things are pled under the Second Amendment in Washington State, we're kind of doing the Bruin analysis. And so, yeah, these are protected. So I could see them denying the claim on the Washington Constitution while upholding the claim of constitutional protection under the U.S. Constitution.
Which is interesting, because we talk about the U.S. Constitution being the floor.
And
so how does that work?
That's why I always wrap back to that's probably not reality.
Yeah.
But I could find some sort of nuance, because they did talk about Jorgensen, which is the case I mentioned of the jerk, and reasonable regulation. I could see them saying, okay, well, Bruin doesn't allow for why is it escaping me right now? Interest balancing, but Jorgensen basically allows for interest balancing. So I could see them positing the two against one another.
Interesting.
Yeah.
That would be really interesting.
It'd be balanced too.
Wonder how that changes changes things
Well,
going
then that
forward.
begs the question of whether or not there's value in taking that question to the Supreme Court. So, I mean, I I think they're probably the most likely scenarios they're going to have to go all in or all out.
Right. So, and this is a tangent. I know that there's a bill being brought forth to restore people's rights, felons in particular, certain rights. Do you ever see them restoring felons' gun rights if they're going to restore their rights to vote or other rights? And what legal grounds would they have to restore one right and not another?
Yeah, I
Because at this point, I think that the right to vote is just as dangerous as
yeah,
being able to
I
have a
agree
gun.
with the statement. I don't know that they could. I mean, I could see them not restoring firearms rights to dangerous felons, but restoring it to more white collar type criminals like financial guys.
Bank fraud,
Yeah, non-dangerous.
non-dangerous.
So
But I bring that point up just so that I can hammer home the point that the bills in front of our legislature this year and going forward absolutely involve and will apply to every single one of you listening and anybody that you know that lives in the state of Washington. It's no longer bills that are being placed in front of them that have to do with policy on transportation or policy on, what ferries can be built or not built, or any ludicrous policy or thing that the general public really doesn't care about. These are absolutely issues that affect your individual and personal rights and will reach into your life and pull you out of whatever peace that you currently have. And it's just a matter of time before it affects you personally. So if you are not involved in what we're doing and not involved in what the state is doing, you're absolutely wrong. And I'm calling you to repentance right now. Get involved, know what's going on, and do your part locally where you stand. Lift where you stand. That's what we talk about at the end of the year. Lift where you stand. Do what you can to make your difference and fight back and retain our rights and regain our rights. Anything else, Pete?
no, that's about it. I'm on dad duty. Got to go pick up kids.
Yep. And we're glad to have you back.
Yeah, it's good to be back.
Full time. I know you were doing so much work. I hate to say full time. You were working full time doing this as well as campaigning. You just weren't in office. And it's nice to have you back in the office to talk about these things. And hopefully we'll get some more podcasts out in the next few days, weeks.
It's good to be back, and we will get more engaged with our folks.
We will update it. Hey, thanks for listening, and keep fighting.